today's podcast, another appeal win for Morris Fischer, LLC. Big one, case Losito versus Mayorkas. And as we enter the last 2 months of 2022, I wanted to share another huge win for my law office. I want to say that this took about a year to get the decision. We understand the client's frustration and how long people have to wait for these decisions. Unfortunately, the legal process just has its own timetable. I will tell you that Mr. Losito getting the call out of the blue was really delighted about this. And we're going to go through this case because it has a number of important points to it for people going through the EEO initial process. This was a discrimination case, still going on apparently because the Office of Federal Operations threw out the court's dismissal. And basically, Mr. Losito, he's getting a 2-year promotion from September 2017, and it's going to go to around the end of September 2019 initially. And at the end of 2 years, the promotion is supposed to turn into the full-time promotion. So he's doing this for 2 years, believing he's going to get the full-time promotion. He gets all kinds of mixed messages in terms of whether he was getting the promotion, whether he wasn't getting the promotion. He finally, in September 6, 2019, he got notice that his original job, this GS-13, which was a grade lower than the promotion, was waiting for him in New York, and he had to fill out some paperwork for that transfer. A week later, his second-line supervisor tells him not to fill out that paperwork because, hey, you're going to be here for a while in Virginia in the cyber unit, and you're going to be here for another month or so. So you're still going to have the temporary promotion. And he finally gets a call, and his reassignment, he is told, is going to occur November 1st, 2019, and he contacts the EEO counselor 3 days later. So the question is, when does the 45 days start that require him to contact the EEO counselor? Is it when he finds out that he's not getting the full-time promotion, which is sometime in August? Is it when he finds out that his promotion actually ends, and he has to be in New York on a certain day? Is it even the day that he's supposed to be in New York, the actual day that it ends? And the government argues, sorry, guy, you found out that you weren't going to get promoted. You suspected discrimination at that point. That was sometime in July or August. You never contacted the EEO counselor within 45 days of having that reasonable suspicion. Therefore, your deadline has passed. And we argue, no. The day that he finds out, it doesn't matter. There's got to be a personnel action, and that personnel action, that doesn't start until November 1st, the day that he's supposed to be back in New York. Okay, so the judge gets one of these motions to dismiss, and I remember the way it was brought up because I was at that conference, and the judge seemed kind of hurried. Defense lawyer or the agency lawyer kind of springs this on her out of the blue. In fairness to this administrative judge, she did allow the parties to brief the issue. But I think she got the sense that, hey, yeah, this is a case we can get rid of right here. This is a timing thing. Yeah, let's see how we do this. Okay, and she cites this opinion, Benny versus Department of Energy. And she says, oh, this case is very similar to this Benny versus Department of Energy case. And let me tell you about that case. The court in Benny, this is the OFO, essentially held that if a federal employee applies for a promotion from, let's say, a GS-13 to a GS-14, and he finds out that he's eliminated or she's eliminated in the selection process, for example, he or she didn't make the interview round, and he or she believes that's because of discrimination, the court holds the 45 days become effective on the day that the person found that out. Okay, now here's what I'm sure that lawyer argued in Benny, the lawyer for the complainant. The effective date, no, Judge, the effective date is the date the personnel action starts, which is the date the promotion would have started for whomever it was that got the promotion, or at the very least, the day that it was announced who would get the promotion. And it's not my guy, so the 45 days should start right then and there. And here, if you look, it's interesting because here the cases are distinguishable. And one thing I did cite in my brief, 29 CFR 1614.105 states, an aggrieved person must initiate contact with the counselor within 45 days of the date of the matter alleged to be discrimination, or in the case of a personnel action, within 45 days of the effective date of the action. And the question is, what is the effective date of the personnel action? Anytime you can cite directly to the regulation, you should, if the words of the regulation actually help you. And here they do, because here they say you need a personnel action. So you need two things. You need a reasonable suspicion of discrimination, and you need a personnel action. Benny, the case cited by this administrative judge, is different because in Benny, what you have is a person, let's say, in box 1. Let's call it status 1. And that person is trying to get a promotion. He's trying to move up to box 2, status 2. The day that he finds out that he's eliminated due to discrimination, that effectively is the personnel action for that guy. Okay, even though the personnel action might be different, the date might be different for a different guy. Let's say you had someone else who didn't have that reasonable suspicion or even made it to the interview round and didn't get selected. Okay, so for that guy who didn't get selected, the day that he found out he didn't get selected, that's the personnel action for that guy. For this other guy, for Benny, it was the date that he found out he was eliminated from the competition. That, we argued, is different than Mr. Losito's case. Mr. Losito's case, if you look at the picture up here, he is already at box 2. He's at box 2. They are trying to move him down to box 1. So the fact that he has a reasonable suspicion that this will take place, it doesn't matter. Because even after he finds out the job is going to end, the promotion's going to end, he's still doing the promotion. He's still doing the GS-14. So he's still in his higher status. So because of that, you don't have a personnel action until he's actually moved down to the lower box. So you need two things here. That's the point. You need a reasonable suspicion of discrimination, and you need a personnel action. I love this language here in the opinion. You'll always love to see this when the OFO says this, and we've got it highlighted. And basically they say, yeah, we understand the agency's contention, and we also understand the arguments, and in finding the effective date of the personnel action to be dispositive, we considered the AJ citations to Purcell, which was a similar case, and Benny. However, we nevertheless remain unpersuaded for the reasons discussed in complainant's appellate brief. You'll love that. That's basically saying, look, Judge, we heard you. Okay, we're not going to regurgitate all this. We heard you. Mr. Fischer said it in his brief. He explained it. Okay, you didn't. Sorry, you lose. Okay, here's my point. One of them anyway. These cases can be very, very complex. There is no question about it. There are all kinds of small distinctions in them. Okay, Mr. Losito had a good case, and they're looking to knock it out. And you've got some crafty agency lawyer and some judge who's not really having the time to consider the distinctions and consider the nuances in the law, because many of them can't. It's not their fault necessarily. They have loads and loads and loads of cases. And I'm sure this is a fine judge who just got it wrong this time. It happens. It happens all the time. It happens in any profession. There are doctors who get it wrong, whatever it is. But because someone made an error and got it wrong in your case, that doesn't mean that you should suffer the consequences of that. Anybody who is going through an EEO case at various points, you should contact our office. We can help you. We know the strategies. We know how these cases get lost. We know how they can win. We know the nuances, and we can save you a lot of aggravation by getting your case on track. We invite you to subscribe to this YouTube channel, and also we invite you to send any comments you may have if you want to hear future podcasts on some issue that's really important to you that we haven't done yet. Let us know that, and we can do that.